So, ladies and gentlemen, we are recording this webinar. Welcome once again to our webinar on understanding the role of the Data Protection Officer. This is a webinar brought to you by the Personal Data Protection Office that is under NITA Uganda. It's an independent office under NITA Uganda. So if you will allow me, I'll introduce myself and then I'll give you a preamble or set the stage for this webinar, and then we'll dive into the gist of the matter. My name is Angela Tugume. I'm the Manager Data Protection Affairs at the Personal Data Protection Office, and I am your host today. So welcome to the webinar. I'll set the stage for this webinar. And we know that Uganda's Data Protection and Privacy Act requires that in as far as it applies to an institution, the head of that institution shall designate a person as the Personal Data Protection Officer. Now, that is DPO. The DPO is responsible for ensuring compliance with the Act, but DPOs also guide on the development and implementation of an organization's data protection and privacy program. So this being a new role, this webinar will focus on the role of the Data Protection Officer. The webinar will offer guidance and answer many queries we have received so far on how best to put this requirement into place. It also gives an insight on who is best fit for this role, their roles and best practice in driving compliance with the Act. Now, this role, the DPO role, is a key role in ensuring success and avoiding data protection and privacy pitfalls, some of which can be costly to the institution or to the organization. So ladies and gentlemen, that sets the background or the stage for why we are having this webinar. So allow me to let us know who's on the call or who's a panelist. On the webinar today, we are privileged to have our director, Ms. Stella Albertese, who will give us just one or two quick remarks. She will essentially just say hi to us and let us go on with the webinar. And then we'll also have a very quick overview of the Data Protection and Privacy Act. And this will be done by Mr. Baker Birukuja. This will also set the stage for the Act, why the Act, so that as we get into the DPO discussion, we actually know where this role is coming from and why it's very important. And then we'll have our presentation from our speaker, Mr. Hakius Bizure, who will take us through the role of the Data Protection Officer and will help us understand why this role and why it is very important for us as data collectors. So that's the flow of our program today. And if you'll allow me, I'll invite Stella to give us one or two remarks and set the stage for the webinar. Thank you very much. Stella, you are very welcome.
Thank you very much, Angela, for introducing the topic today. I think you've really elaborated why we are having this webinar today. I want to welcome all the members, all the participants on, who are attending this webinar. And I'm hoping that once we are done with it, you'll have a better understanding of the role of the Data Protection Officer. As the Personal Data Protection Office, we intend to conduct webinars at least once a month to be able to provide highlight and detail on most of the issues that we know are important to enable you comply and to make it as easy as possible. We want to make use of industry experts such as Mr. Hakius Bizure, who has volunteered his time to be able to provide us the practical aspects, because we don't only want to talk about the law, we want you to hear it from, we want you to hear it in terms of the practicability and the practical aspects of it. So we thank you, Mr. Hakius Bizuri from Ernst & Young, and he's also a very valuable member of the ISACA team. We thank you for partnering with us to be able to create as much knowledge as possible in this new space in our country. I wish you a wonderful webinar. Thank you.
Thank you very much, Stella. So those were our remarks from Stella, the director for the Personal Data Protection Office. Now, allow me invite Mr. Becca Birukuja. Becca is the manager, legal and licensing affairs at the Personal Data Protection Office. Becca will essentially take us through an overview of the law, just so we have an understanding of where we're coming from. Thank you very much.
Hi,
Becca,
Angela. Thank you, Angela. Just before Becca comes, I have a hard stop at 12. So if that's okay, can Becca come after I talk? If that's okay, thank you.
Okay. Thank you, Achilles. So I think it's okay for us to do the role first, and then we'll take questions, and then Becca will come in. Okay, so Achilles, you can actually take the floor.
Okay. Thank you very much, and thank you, Becca, for your understanding. So Angela, you can help to give me control. Thank you.
Yes, I'm working. Gary, can you help us with that in a minute?
All right, thank you. And I would also want to just pass my regards. Good morning, good afternoon, everyone who has joined. I see we already have 86 people who have joined the webinar, and this is really exciting for us because it just demonstrates the interest and the importance of this particular subject. So I think as Angela gives me rights to share my presentation, I think basically what I want to talk to you about is the role of the data protection officer. But of course, before I do that, what I also want to just give you is a bit of context around what's happening, what some of the terms that we use in the industry, but also just to maybe give you some insights around what's happening, which probably inspires the data protection officer role. And the role itself is evolving, and I think that's one of the key things that you will see over time, that it is going to be inspired by a number of changes that are happening not only in Uganda, but across the world. So even as we discuss, let's appreciate that this is not going to be a static role. It's actually going to be one of those roles that are continuously going to change or adapt to the changes that we are seeing in this world. So Angela, just confirm that you can see my screen so that I can start. A simple yes will do. Thank you. All right, thank you very much. So what I will do is give you the overview of protection in privacy, because I think we cannot always assume that everyone understands.
You're back.
Sorry?
We had lost you for a moment there, but you're back. Thank you.
Okay. Yes, so I think in terms of overview of data protection and privacy, some of just the key terms, and then maybe look at some of what are those drivers that are helping us to understand data protection and privacy, and some of the key precedents, which I think are important as to your point in as far as why we need this role. Then we'll just talk about the data protection and privacy officer role in terms of what it is, particularly from the Act and regulations. And then, of course, how is this role essentially managed across other jurisdictions? And here, what we want to be able to do is just to give you some insights from our side as EY, or as well as industry professionals, around how we are seeing this role being managed across the different roles. So that's a bit about myself. Of course, I will leave you with a slide to know more about me. So when you look at, I think the key terms here, data privacy and protection, I think where this comes from, essentially there are three dimensions where we have information privacy, which I think we normally find it extends beyond information security, and it considers the life cycle of personal information and the business processes that it uses. And on the other side, we have information security, and this is the foundational set of services that organization needs to implement and protect what we normally call confidentiality, integrity, and availability. And when they come together, I think what we then see is we have what we call security of privacy. and which is the protection of personal information against unauthorized and physical and logical access of this information. So essentially, there cannot be any privacy without security. And of course, information security professionals who are out there, security alone does not assure privacy. So this just helps us to set the context. And when we then moved in terms of personal data, and here we're just talking about any information related to an identified or identified natural person, which we refer to as a data subject, right? And it comes in the form of identifiers such as name, identification number, which could be your NIN, where you're located, and any online information, your email, that's personal to you. And of course, what we also see is that there is what we then refer to as what is processing of data. And here is, we define it as an operation or set of operations which is performed on personal data, whether or not through personal means. So it doesn't necessarily mean that it has to be automated, but here is how are you going to manipulate this data? It could be recording, it could be retrieval, it could be viewing, it could be disclosure by any organization. So, so what we're essentially saying is that doing almost anything with information relating to a natural person may constitute processing of what? Of natural personal data. And the good thing is that when you look at regulators, they do not distinguish between the two, because whether it's digital or paper-based information, what they tend to be concerned with is whether this information is actually personal data. Okay. So of course, we also have data controllers, and we are data controllers essentially when we decide what to process, when you determine the condition of processing, and when you have a privileged point of contact. And we are data processors when we process data on behalf, of course, of a controller. So these are the essential things probably we need to think about. And in both cases, the controller and processor sometimes can be involved in the same, can have shared responsibility within an organization. So this is just setting the context, but of course you would note there are certain drivers that we are seeing, which we need to be mindful of. What is driving data protection and privacy? I think the impactful developments that are happening. First of all, when you look at COVID-19, it has catapulted most of us into the digital age, where we are now sharing private information digitally. And of course, when you then look at it, some of the main drivers include cloud services, which are now used to store data. Growth in innovation means that there's so many solutions out there that are actually driving personal data. Customer centricity, where we talk about terms as market of one, for organizations to be able to serve their customers better, they need to know more about them. And that involves collecting large amounts of data. And bring your own device to work is one of the elements, I think, where you also store not only company information, but personal data and personal information. Internet of Things, devices, mergers and acquisitions, big data and analytics. And I think we're in an era where, because of all these factors I've talked about, I think there's a lot of data that is being collected about personal information for people. And then, of course, the social media growth. I think you've seen a lot of personal data that I think is being shared across different platforms, be it your Facebook, be it on Twitter. So the overall developments actually now bring privacy and digital challenges now, which we need to think about. And of course, I think overall, you have seen this in the headlines in terms of breaches where, for example, Facebook, I think, has been in the headlines with a breach of at least 120 million data points in terms of personal data. We've also seen some breaches that were coming in around Marriott, where credit card data was manipulated, Twitter, and many others. So this now helps us to start thinking to say, okay, based on the drivers or challenges I've shared, the reality now is that the risk is actually exponential over the years. Of course, we are still in early days here in Uganda. which is quite interesting. But other countries have actually moved ahead in terms of actually enforcement of these privacy laws. And you find here in the UK, a ride-hailing app, I think is Uber. At some point, it was actually fined £385,000. Between October and November 2016, there was a cyber attack that actually affected 2.7 million customers and 82,000 drivers in the UK. So the issue, of course, was the breach. Was a serious breach of the data protection, and part of the reasons were there were avoidable data security flaws that could have been addressed, and attack was not notified to the ICO, okay, which is an equivalent here to our data protection office, and affected individuals were also notified. So, of course, as the case proceeded in November 2018, a fine was eventually issued. And what lessons here we find is that we do not conceal or breach information about your data subjects. Inform the regulators such as NITA and individuals at every point in time. So these are the realities that your DPOs are likely to be discussing or at least sharing over the time. Social media platforms, again, I think here there was a breach, and the issue again was on breach of principles, misuse of personal data, and alleged failure of efficiently protecting the privacy of user information. And again here, we learned that transparency and data security are paramount. And again, we start to see the key things that will help us as we define this role. Again, we have another case study here, I think, of Nadel's case, which was about 20,000 euros. And what happened is that a hacker attack resulted in personal data from approximately 330,000 users. Here we're talking about passwords, email addresses, etc. In the data breach notification to the Data Protection Authority of Biden, I think there was a challenge. And what we then saw is that there was a penalty. And whenever there's a breach, rather than weighing it out until the end, the most important thing is that you need to ensure that you collaborate with the Data Protection Office here in Uganda. And this helps to manage or at least reduce the penalty. So, of course, what we know is that some of these litigations actually increased over time. And I've just shared with you some of the cases for your own reference. But when you look at it from this perspective, this is the time you actually then start noting that, look, this can actually happen to us. So whenever there's a breach, have you communicated? Have you collaborated? Have you taken the active steps? And in these cases, which I've just talked about, the countries, you would notice that there were penalties that were suffered. So this is what actually helps us to shape the role. What I wanted to just talk about, I think, is just in terms of the evolution. What are the drivers that are going to of privacy that I think we need to think about as we start to talk about the role of the DPO? The first one, I think in the past, when you look at organizations or enterprises, in probably where we are right now, I think mostly what organizations are looking at is mostly compelling in terms of securing the data. There's little to no investment in securing personal or customer data. And when they use data, they're thinking of saying, okay, let's use it for what? For a competitive edge. But if you look at now the drivers that are coming in globally, even locally, I think when you look at COVID-19, it has taught us that we need to start securing personal data. And what we're also seeing some of the drivers is that efficient digital transformation requires that robust data protection framework is in place. Here we are seeing it from the examples I gave earlier on your Facebook, where there was a breach. So the present or potentially the future, when we are down organizations here, is that they need to now start considering privacy as a necessity for smooth business operation in the new normal, right? Working from home, remote working, moving into the client. And then also the other thing that's actually coming through is that planning for higher investment in data protection is a strategic one of the strategic priorities, because if you don't, you'll be fined. And it can also lead to reputational risks. So even if you're looking at the role of the DPO, these are the things you need to keep at top of mind. And then, of course, when you look at the regulators, I think in this case, of course, we've got the law, but they say the Data Protection Office here in Uganda, we noticed that, of course, the existing regulations cover data privacy, but lacked the accountability of data controllers. Okay, then the fines were not high and implementation was lax. So if you look at the law in Uganda, it's quite onerous in terms of some of the penalties. I think if you really look at it, if you are into breach, but it has actually not been activated. Okay, so we are still in the early days. But of course, when we then look at the drivers, which are with us, rapid digital transformation in terms of storage, amounts of personal data and corporates, we are seeing this not only in banks, but even NITA under digital acceleration. There's a government cloud that is in use. We're also seeing not only in the financial services, but across the industry, there's a significant growth in data breaches. And the misuse of personal data, I think, is one of the biggest questions, especially when you look at privacy or from an individual perspective. And the regulator now is becoming increasingly concerned. So I think now when you see the shift, the shift for NITA now is quickly going to move towards adoption of accountability principles for the privacy implementation. So focus on large tech companies here in Uganda. I think we've seen a couple of breaches, but also the entities that are here. How are you managing personal data? And whilst, of course, the penalties have not been effected, I think if the things that I've talked about earlier on are not addressed, what we are likely to see is that we're going to experience a lot of heavy penalties for data breaches or misuse of client data. So, and I think that's where the push now for the DPO role is going to come from. And of course, the consumers, I think the awareness has really been growing over the years. And I think if you look at the Facebook issue, most people, and even WhatsApp, I think when there was a privacy concern around how the data would be shared, most people are really very conscious about this. And the trust has been depleted for these big tech and other organizations around how they use their data for value creation as well as of profiteering. And also consumers are a bit concerned to say, okay, how are you going to, if you're going to share data, what's the return on investment? What do I get? What's in for me? So when you bundle up this, these are some of the drivers that we now need to think about before we talk about this role. And I'm sharing this so that at least when you start talking about the ticking boxes of this role, at least everyone has an understanding in terms of the context of where this is coming from. So, of course, we've got the act is in place, the regulation is in place. I think as of last time, in the previous presentation I made was that in the definition of the data protection officer, the roles and responsibilities within the regulation, there was still a gap. But of course, the act itself, which we shall talk about, and as we talk about the role, you then notice that it's quite onerous, and the responsibility of the DPO is quite broad. So it's very important that organizations are aware of this. I felt at this point in time, it's also important to produce another nugget, which is we as Ernst & Young, we carried out a data protection and privacy survey, and our first one was in Kenya. And we asked a question, does your organization have a data protection officer? And then we noticed that only 45% had implemented the function in Kenya and 55% had not. I would imagine maybe for Uganda's perspective, you might find that the stats could almost be more or less the same, but of course we are going to find out. But what we also wanted to find out is that, okay, fine, for those ones who have implemented this data protection officer role, do they have any additional role that they fulfill? And what was interesting is that 85% said yes, and only 15% of the respondents in Kenya then said, look, this is a standalone role. But more in organizations that have this role, they're doubling up either as internal audit, chief risk officer, compliance role, data governance role, information security, legal manager, and operations related. So essentially, what we are seeing, I think for some of you who might be or thought about this, probably this could also be the mix that you've determined for your own organizations. But where I'm sitting, I think the way I'm observing this is that it's going to be a blend, but it might also be a risk in future if it's not a standalone role because of some of the responsibilities that come with this particular role. Of course, when you go to the Act, Article 5, the Data Protection and Privacy Act, when we talk about the Personal Data Protection Office, which is established under NITA, it oversees the implementation of and the responsibility of enforcement of the Act. So that sits with NITA-U. I think that has the overall mandate, which I think right now is in full force because the office is in play at the moment. And what is also interesting, I think, as we think about the role, is that according to the Data Protection and Privacy Act, Article 29, it talks about data protection register. And it states that the authority shall keep and maintain a data protection register. And then the authority shall register in the data protection register every position, institution, or public body collecting or processing personal data and the purpose of which it is collected or processed. And then Article 30 actually proceeds then to talk about that the register shall be available for inspection by any person. So I think even as we are still struggling to talk about this particular role, you can see that this is a mammoth task to actually have all this in place in terms of registering with the authority. I don't know how many organizations have actually done that, but if I would imagine that a number of organizations are already in breach, and from a compliance perspective, and the Uganda Minister of ICT through NITA-U will provide the competence on the clear and transparent requirements to be set out by itself to register and certify. So here, what I just want to say is that I think we need to think clearly before we get into the role around some of the things we need to put in place. Here, of course, in terms of the data controller, I think data protection, I think in terms of the act or regulations of 2020, it says that the authority shall have the authority shall have all the following investigating powers, okay? To carry out investigation in the form of data protection audits, to obtain the data subjects, controllers, and the processors, access all personal data, to obtain access to any premise of the controller and the processor. So, of course, here we're talking about on-site inspection, file inspection, data protection audits. And if the question I have is that if this happens today, how many organizations will be ready? How many will be able to respond and provide this information as required if they've not complied with the article number 29, which I talked about? And you can see how the role starts to shape up. Then, of course, the other aspect now starts speaking to accountability, which is defined by the regulation, I think Article 4, application for registration. So I think here we need to ensure that the controller, how they need to describe the measure that they are going to take on personal data, and which include implementation of appropriate data protection policies by the controller, demonstration of compliance through written undertaking by the applicant via the Data Protection and Privacy Act through form, okay? So of course, the things that we need to now start thinking of is that in our processes, do we have privacy by design? That's in terms of the DPO. Do we have privacy by default, where we are throughout the process, thought through the processing of the data? And those are the players that sit in there. Then, of course, we then talk to the specific role, which is in Article 6 of Data Protection and Privacy Act. And it talks through to the data protection officer. And it's quite interesting and how broad it is. For purpose of this act, and insofar as it is applies to an institution, the head of the institution shall designate a person of the data protection officer responsible for ensuring compliance with the act. So I know, of course, through today, we shall have an overview of the act, but it's quite broad in terms of what this person is going to be doing. The question that comes to mind is, how are they going to carry out this role? What competencies do they have? How are they going to interact with the respective members in the organizations? Of course, when we look at the regulations, I think one of the things I tend to be guided, but we did not see roles and responsibility defined. So what I probably want to share with you today is the precedents and best practice that come from, for example, the GDPR and other jurisdictions that helps us now to start defining this role. So I think some of the things, I think, as organizations have this role, what do you need to think about? the first part, I think you need to make sure that you are appointing this role on the basis of professional qualities in particular, and you need to also think about the knowledge of the organization, the size of data that you are going to handle as an organization, right? So sensitivity of the information, complexity, volume of the data processed by the controller or processor. So obviously, if you're a telecoms and you are processing large sums of data and you also have complexities, it means that the person has to have the competency to understand the organization from that perspective. So what we talk about here is also what is also quite significant is that beyond the technicalities I've talked about, you need to understand the data protection law or laws. And why do I say this is that in Uganda, we've got the Data Protection and Privacy Act, but we don't exist in a vacuum. We also are interacting with the East African community. We've got GDPR, we've got POPI in SA, for example. So that person needs to understand the intricacies of these respective laws. Then, of course, you need to have an understanding of processing operations carried out. You also need to have a good understanding of information technologies and data security. So this means that, so beyond knowing the law, you need to know the technical aspects of the technologies that you're using to process the data. And the more complex it is, it then talks or speaks to the role that you should have. And you also need to have knowledge around the organization that you're working on, as well as the sector, because it's beyond knowing the law, but it's also around understanding some of those sector insights and risks that are going to lead to what? To breaches. And then you also have to have the ability to promote data protection culture within the organization, because it's not necessarily tied to the role. You need to think through in terms of the varied facets that are within the organization, in terms of how, we'll look at an organization as an ecosystem. So how is data protection and privacy going to affect the different roles within your organization? And of course, what we also need to think about is that when you have this role, we need to have active support from management, because it's very important. And it's very complex, so it needs to be given time to fulfill their tasks, because if there's any breach, remember I shared with you some of the penalties that come through. So they need to be given the right support. Sometimes it would come in the essence of additional, what we call roles or support roles. And then, of course, I think because of things that are ever changing, we need to also think about consistent or continuous training. So according to GDPR, I'm quoting GDPR simply because of some of the issues I've raised. I think the controller and processor shall ensure that the data protection officer is involved properly and in a timely manner in all issues which relate to the protection of personal data. So what we are then saying is that even as we structure our organizations, as we structure our processes by design in organizations, this particular role has to be involved in every aspect of of the organization, right? So then there's another aspect, I think the second one, which talks to the fact that the data protection officer does not, the controller and the processor need to ensure that the data protection officer does not receive any instruction regarding the exercising of their tasks. He or she shall not be dismissed or personalized by the controller or the processor for performing his task. So the data protection officer shall directly report to the highest management level of the controller or of the processor. So I think this is a sobering thought, especially when I see how the role has been bundled up in other roles. I am picking to the case of Kenya, where 80% at least are bundling out that role. This should be a standalone role. And for the reasons that it needs to be allowed to carry out its activity, it needs to report to the highest level within the organization, right? And for that reason, I think it needs to be supported and must not be interfered with. But of course, I think because of the nature of the role, I think one of the key things, that particular role also has to be bound by secrecy and confidentiality. So does this person that person able to hold confidential information about the organization, but of course acting within the law, right? So the other part, I think, is that the person has to be of high standing, and at every point in time, you need to ensure that there's no conflict of interest and in terms of carrying out the duty. So at any point in time, this must be reflected in that particular role. So in terms of this particular role, I think we also need to ensure that there's monitoring with the Data Protection and Privacy Act. So it goes all the way in terms of extending monitoring the compliance with the Act. So that could include collecting different data sets, which I talked about, and ensuring that we are in the right side of the law. But also, it's important that this particular role, they must be close to the Data Protection Office, in the sense that they need to be consistently be engaging on potential and actual breaches around privacy, and seeking guidance to ensure that at least the regulator is in the know-how and is able to advise. And this is potentially a risk-based approach in terms of managing this particular role. So you will notice that I think the Act talks about data privacy impact assessments, and I think this is important, which is a litmus test in terms of how an organization fares around data protection and privacy. So the DPO role should also extend in terms of ensuring that data privacy impact assessments are conducted on a regular basis. There's the methodologies is followed, and all the remedial actions or at least recommendations are actually implemented or as advised. So probably this is one of the key things. But of course, you notice that because we are living in a global universe, and the role of the DPO should also extend beyond the organizations, particularly when there are cross-border breaches, and ensuring that at least we notify the authority in terms of any of those breaches as they occur. So one of the key things I think that I just wanted to focus, you see, there are challenges based on what I've talked about, and we're noticing this in a number of organizations. First of all, the role itself, it's not one throng in terms of this should be a lawyer, it should be an IT, it should be a business person, as you've seen in terms of the quality. So it's actually a multidisciplinary role, which could include somebody who understands legal, who understands technology, who understands risk, who understands the business perspective and privacy, right? So it's almost an all-rounder type of person. I think when I look at this person, is called probably somebody who understands the different functions within an organization, or has worked through, not necessarily holding the qualification in all these areas, but just has a good understanding. And the DPO has to inform and advise the controller or the processor and the employees who carry out processing of their obligations, which is also very important to say that how do you maintain a balance of the two particular role. And then the other part is that you have to comply with the Data Protection and Privacy Act, the GDPR. So I know in Uganda, we're talking about the DPPA, but remember, we are also bound, depending on how our organization is structured, to other laws across the world. So how are we responding? How are our internal policies actually geared towards that? And they also have to act as a point of cooperation with the supervisory authority. So in this particular case, of course, through NITA, the Data Protection Office, it's a point of contact, but I actually see this even extending beyond the supervisory authority, but also other organizations or other institutions. So, but of course, organizations are responding differently to this role. Of course, a different mix. I think it now ties down to practicality of it. So we are seeing larger organizations actually. So for example, if it's like your KCB regional bank or your Equity Bank, if you like, or they tend to want to appoint one probably DPE or for each local entity, but appoint some of those responsibilities, I think, reporting into the group. Okay, so this is more around creating different lines of defenses. Some of the activities are bundled up to some of the things that I've talked about. There could be risk, legal, CISO. They could also be compliance. Okay, so I think from my perspective, if you were to ask me how this role fits in, I think from what we are seeing is that it sits at the center and it works through the different functions of the organization. And what do I mean by that? I think we'll have your legal and compliance on the other side. They have to understand the regulations and laws. They have to ensure that the privacy guidelines are compliant from a regulatory perspective for the organization. So they will be looking into the legal matters of the act and how the different processes and policies and procedures actually comply with the law. Then of course you have the risk management teams within the organization. Then they perform the private impact assessment and work with the data protection officer to ensure that it's done and they support with the reporting. They balance the implementation and compliance with the privacy requirements, and then they identify and prioritize the mitigation actions. Okay, and then the CISO on the other side, I think, is more around coordination and to document the privacy assurance program activities, conducting the respective tests, overseeing privacy-related risk assessments, and then internal audit. I think on the last part, I think they tend to want to ensure that we address data security privacy risks that are most significant, and they also identify weaknesses in the policies and procedures. So the DPO now sits at the center to monitor the compliance with these regulations and acts, and provide advice on privacy impact assessments within the organizations, monitor the responses from the supervisory authority. And I think it's a significant role that has an overarching, and that's why it's important that it fits into the senior management role, or at least directly to the executives, or sometimes to the board, to ensure that at least these roles and responsibilities are streamlined. So I think this is basically what I was talking about, and we just need to think about the insights to say when the DPO is at the center. If you have got depending on your operating model or as an organization, how is that role going to fit in? Does this DPO need to be a lawyer? So sometimes, depending on the provisions within the act, as well as the different jurisdictions that you're dealing with, you then ask that question in terms of how your organization would fit. How will the breach notification work within 72 hours or more? So here the idea is how would the DPO would respond. Some organizations, of course, when you look at these capabilities, they ask themselves, you know what, this is quite significant for us. What we've seen, a number of organizations actually have started to outsource some of the roles or functions, or co-source them to ensure that at least they have the adequate support. And again, remember, I talked to the fact that it depends on the complexity of the organization. And then, of course, one other role that they will think about is, okay, look, can I create a culture of data protection in my organization? So it's purely around creating those particular elements that will help to drive that conversation. So, of course, I think for me, in closing, we just need to think about, beyond the role, what is the impact of not complying, right? Okay, so there are risks and sanctions we need to think about, particularly within the DPO, and that's why I emphasized in the presentation that the DPO should closely work with NITA, okay, and the Data Protection Office, and then the organization should also register, right, their activities, because it's the law, and that's what it is. So you don't want a situation where you then have class lawsuits and you don't have notifications of breach of notifications. You sit on information saying, okay, we don't want it to get out. That's actually breaking the law. So you also want to then be able then just to make sure that you have the right compliance. So of course, what we notice, I think in Uganda, of course, there's no cap on compensation of damages, isn't it? Because when you look at GDPR, you can be fined up to 20 million or 4% of annual worldwide turnover. Okay, but in our current act as it is, I think it's quite onerous. So it therefore means that we are sitting on a big risk if we actually don't get to actually address some of the risks that come with it. So I think we just need to move towards compliance and also embed it as part of our DNA, just to avoid some of the risks that we think about. Of course, the first part is to ensure that you have organizations that comply obviously have got benefits. Their brand reputation is also will be amplified. It could be a competitive differentiator in terms of how customers perceive how you protect their data. Then, of course, you want also to avoid data breaches because they can be costly. So I just want to pause there. Of course, I have got the slide made.
Hackers, we have lost you, or have you paused?
Which I can also. But this is what I wanted quickly. Thank you. So sorry, you said what? You lost me, right?
Yeah, we lost you at one point.
Yeah, I was just saying those are the overview. I tried to just share with you the overview in terms of some of the things that are key. But I wanted to tell the story in terms of the DPO from a
Hackers, we lost you once again. Hackers, we have lost you once again. I hope the fault is not on my end.
So that you can start around how you plug in the role into your organization. I was using my phone to tip. So, but anyway, I've concluded. Maybe I could pick one or two questions in the next 5 minutes.
Yes. Hackers, thank you so much for your presentation. Very insightful. You tied the notes together into giving us a proper understanding of this DPO role. You didn't just throw us into the role itself and what it requires and what it means, but you actually took us from point A to the last point. So I believe the attendees have a very good understanding of not just the role, but of why the role is necessary, and also around the fact that it's looking at the complexity of the organization. You can decide to create a new role. You can decide to give additional responsibilities. You can decide to outsource the role. So those are the three options that you actually have under the DPP Act as well. And so it's up to the organization to look at their complexity. Thank you so much. This has been very insightful, very informative. Please put your Q&A section and we'll respond to them. I have quite a number of questions, and I think I'll just read them out for you. Would you prefer me to do one at a time or three at a time? Okay, Hakius, are you still with us?
3 at a time, that would be
okay, good. Cool. Perfect, thank you. So the first question is, where do you draw the line between data protection and restricting access to information to those whose work depends on this data? The second question is, what are the consequences of having a data protection officer as head of audit? Does that not lead to conflict of interest, considering the role audit plays in privacy? And then maybe then the last one, the third round is there a certification course for DPO? So Hakius, if you could take that first round, and then we'll move on to the next round.
Okay. So on the first question, I think it's more around the balance between what to share and not to share in terms of privacy. The law, I think, is very clear in terms of intent. Whenever you're collecting personal data, the intent must be clear and be communicated. But of course, I think as you are carrying out this, you also need to be very aware of the risk that are involved in processing that particular data, not only from an organization perspective, but from a user perspective, or as well as the owner of this data. And that's one of the reasons why I said organizations now need to think around privacy at the center in terms of how they design their processes to avoid that particular risk that actually you mentioned, or the question, the person who raised the question. The second question, I think you was centered around the role of between data protection and audit. I think these are, I tried to explain this in a slide where I mentioned the role of internal audit or in terms of the support, right? They will probably be monitoring, right, what is happening from a risk perspective, all those actions that have been raised. But the role of the DPO is much, much broader than that, because they work with internal audit, because they actually, DPO relies on internal audit, relies on CISO, would also work with the legal and so many others. And that is the anchor between the entire organization and the DPO office. So when you look at the roles and responsibility, is quite significant at the moment. And I must say, one needs to also think about it from the perspective of how this organization ties in how they work, isn't it? How much data are they working with, the complexity, the sensitivity, the risks with the data. So I can imagine if somebody is working for an organization like MTN, for example, right? And I'm in a supermarket, our risk profile is different. So which means the DPO of that organization also needs to meet and walk the talk in terms of what the organization that we talked about. And remember, I also talked about the fact that it's not just about internal audit. There are other things that they need to know. They need to be a business person. They need to understand the law. They need to understand risk. They need to understand the technology. So when you look at this role, I think you need to really think beyond what the simplistic view that we tend to have. And then the last part, I think, in terms of the certifications, yes, I think ISACA has them, but also there are also specific data protection certifications that are out there, which you could actually try out. So, but of course, the certifications are a starting point, but the role itself, I think, is much broader depending on the organization. Thank you.
And thank you, Hercules. You make the role sound like all-knowing, an all-knowing role, which in a sense it is, because you must understand the entire business of your organization and the risk profile of your organization. So the DPO must be a very knowledgeable person. So Hercules, I have another set of questions, but most are related. So I think you'll take them at a go. One is, please comment about the practice of appointment of an already existing officer, e.g. compliance officer, head of legal, etc. as DPO. Can the DPO role be outsourced to an external firm, lawyer, or even firm of advocates? And then maybe the last one, who could be the most suitable person for DPO position? Okay, Hercules, if you could take on those. And then the last one is, thank you for the insights. For the case of Uganda, please share more insights on who is responsible for enforcing accountability, controlling activities on social media. Hercules, over to you.
All right, you said quite a mouthful. So, but I think what I would say is that I think when you look at the role, organizations need to think through how are they structured. If it's a complex organization, and maybe by structural wise, you start with what you have. So some of the DPO roles might need to be fulfilled by a single person. But if there are some of the areas that I talked about and you realize that, okay, fine, the legal provisions because of our operating model are different. So you therefore now need to also to think differently to say, okay, let us co-source or outsource some of the functions that feed into the DPO role. But an organization must have a data protection officer, right? So they support that data protection officer to fulfill that role. So maybe that's where you have the likes of maybe Ernst & Young coming in to support on some of those areas to help, okay? But that depends on the structure of the organization. So I think the last part, I think, was I'm just answering generally to the questions that came through. The last question, I think was it on what, social media?
Yeah, about who is responsible for enforcing accountability and controlling activities on social media.
Okay, that's a good question. So the question is, that's a broad question. The first part is we need to look at the provisions of data protection in privacy, right? So the company that is offering the platform also has to what? Has to know the boundaries of the compliance with Data Protection in Privacy Act. If they are collecting information about Ugandans, right? So that's one thing of way of looking at it. But because of social media, other companies are also plugging into this ecosystem and also pulling that data. The question is when they're collecting that privacy data or personal data.
Hackers, we lost you then.
Do they have the right legal provisions to be able to what? Sorry. Yeah. Do they have the right provisions within the Act to manage that ecosystem? So it becomes, it's not just one organization, but I think it's a series of organizations and their roles within the ecosystem to manage that. Angela, I just want to request that I pause here. I'll take whatever questions can come offline, and I'll also share my presentation. I really thank you for your time.
Thank you so much, Akil. Thank you. Thank you so much, Akil, for taking off the time. We have been very privileged, and it's been a very insightful presentation, as you can see from the comments that have come in. So we'll catch up offline. Ladies and gentlemen, that marks the first part of our presentation of our webinar. But what we're going to do now, we're going to answer some of the questions that have come in, and this will be responded to by the PDPO office, Stella and Becca and myself on some of them. And also we'll bring out a few things on the role of the DPO as stipulated for in the regulations. So Stella and Becca, if I could put some of the questions to you, I hope that's okay. Okay, so the first question is when is the deadline for organizations to appoint a data protection officer? Will there be a separate communication from the office to organizations to designate a DPO? Stella or Becca, if you can take up this.
Thank you for that question. There's no deadline for appointing a DPO. The Data Protection and Privacy Act and regulations do not have a transition clause. So following the gazetting of the regulations, which were gazetted in March 2021, it is expected that every organization should, if they are required to do so, appoint a data protection officer. Of course, under the regulations, there are specific organizations that in Becca's presentation he'll talk about that are required to have data protection officers, and the office will be is working on additional regulations to be able to identify who must provide a data protection officer. We expect that all that will have been done by December this year. So if you fall within the category that must have a data protection officer, then you should have done it, yesterday. What we are going to do as an office, we are going to give a grace period that will allow organizations, at least by December, to have appointed data protection officers, and that communication will be coming out. For now, when we engage organizations, the first thing we recommend is that you think about designating a data protection officer. Thank you.
Thank you very much, Stella. So Becca, I'll just ask you to, as you prepare your presentation, I'll just read out one of the questions that is on here, and maybe you will take it up in your presentation. The current regulations do not clearly specify where the DPO should report to. I think this is a gap which needs to be addressed. Becca will address that in his presentation. Okay, so Becca, if you're ready to go, the floor is yours. Ladies and gentlemen, we just have one more presentation that will take about 15 minutes, and then we shall get back to the Q&A. There's quite a number of Q&A that is very interesting that I'd like us to complete with. So let's do one more presentation from Becca, and then we'll come back to the Q&A. Thank you very much. Becca, over to you.
Okay, thank you very much, Angela and Hercules, who took us through the practical aspects. I'm going to give an overview of the law, but in regard to designation of a data protection officer. As introduced, my name is Becca Birikuja. I'm the Manager Licensing and Legal Affairs at the Data Protection Office. Okay, just a minute. Okay, I may be presenting without necessarily projecting, having issues.
Okay, so as Becca gets his presentation ready, maybe Stella, there's a follow-up question on the grace period. Will it also be applicable to the registration requirement? If you could just give 1 second answer to that as Becca gets his presentation ready.
Angela, the requirements for registration are very clearly indicated in the regulations. The forms are already provided. We've already done a webinar guiding on that registration, and you can also find a guidance note on the website of the office, which is www.pdpo.go.ug. So the registration will not have that grace period because we've done most of the work that is required to enable organizations register. So all this information you can find on our website. Angela, if you could provide the link to the URL for the website in the chat. Thank you.
Thank you, Stella. So the link for the website is pdpo.go.ug. I will put it in the chat as well, or Jared can help me put it in. In short, please register as soon as yesterday. Everything is ready for you to register. Okay, if Becca is back on, so Becca, you can take the floor once again as I work on your presentation.
Okay, thank you, Angela. Angela is going to be projecting the presentation in a few, but briefly, I'll talk about why the law. We already have, before the enactment of the Data Protection and Privacy Act, we had sectoral aspects dealing with data protection. We had elements under the Electronic Signatures Act, Registration of Persons Act, under the Communications Act and the regulations. But why we needed this specific law is that, one, it needed to give effect to Article 27 of the Constitution that safeguards communication and privacy of an individual, but then also providing a comprehensive legal mechanism or regulatory framework for the protection of individuals' personal data, and also providing for the rights and the regulations on how to, thank you, Angela, on regulations on how to exercise those rights. Can we go to next? So the other is the law, the application of it. It applies to anyone or institution, public body, collecting or processing personal data of anyone within the boundaries of Uganda. But it also has an extraterritorial scope in the sense that any organization outside the boundaries of Uganda but collects and processes personal data of Ugandan citizens, it applies to them. but even more so the material scope of it applies both to data in its electronic form, but then also data kept in manual, which we call the physical records. So after looking at the applicability, Angela, next. The general definitions, Hercules has been talking about them. If you're a data controller, it's basically anyone who determines the means and purposes of the personal data so that they collect. If an organization is providing a service, they will say, before you can open an account, a bank account for you, we need to have your national identification details and the rest to be able to conduct the electronic or the know your customer obligations. If you have downloaded an application and probably you've ordered for a product using an e-commerce platform, they will need to collect your location to be able to provide with you that product. So those that determine which information to collect and how they will use it are the data controllers. But then the data subject is a technical term that defines an individual. I should emphasize a living individual, non-deceased persons whose information is collected and used by a data controller or processor. A processor is anyone who acts on the instructions of a data controller on how they can use the information on, in respect to those instructions. These can be hosting companies, or it can be a firm that you onboarded to collect the information on your behalf, probably a survey, or to provide the service. And personal data is any information that identifies you from any other person. If a person is able to tell that this is Baker Bijukuja, not any other person, that information is what we call personal data. So the examples are many. There's educational information, identification information, even behavioral for that matter, and even IP addresses. If they can be able to actually say this person is using this device at a particular point, and that information combined with other sets of information, they can be able to identify you. So this law is based on what are called principles. Really, everything else springs from it. The obligations that Hercules has been talking about, what you are required to do, but also the rights for the individuals whose information is collected. So any person who is handling any compliance mechanism, or even as an individual, should be fully aware of these principles. Briefly, one is accountability. We started with accountability because the role of a data protection officer is really hinged on accountability. You should be accountable to the person whose information you collect. And of course, we'll look at some of those, like Hercules talked about, having mechanisms in place of receiving complaints, resolving them within the timelines given in the law, enabling them to exercise their rights of deletion, or getting copies of their data and related aspects. So as a data protection officer, this is one of the very principles that you should be familiar with, accountability. Then lawful, you should have a legal ground on which to collect or process this information. The Data Protection and Privacy Act gives a number of them in the law, but briefly they relate with consent, legal obligation, which is imposed by a law where you should comply. Very many people think consent is the only valid basis, but there are more. There are others where a person may need to collect your information for medical grounds to be able to diagnose, administer treatment and related, but we'd also have one of security. So you, as a data protection officer, it's very critical that you actually familiarize yourself within those grounds and advise your institution on which one to rely on. You can rely on either one or a combination of them. The other is minimality. Gone are the days before data protection where you'd say, let's collect all the information that we may need. Probably we may think of what to use it for in the future. That's why you should, as a data protection officer, think of which information is relevant to be able to provide the service, the purpose for which you need to collect the information, and the obligations imposed by law. So collect only that which will be able to assist you do that particular purpose. In other words, information collected should be minimal in that regard. Then is retention. Retention is also informed by the purpose. So if you're going to provide me, let me say I've ordered for lunch, and then I do not interface with you again, then clearly you shouldn't hold my information unless there are particular exceptions as provided by the law. But if not, then you shouldn't retain it for any longer. But of course, there are laws that require you to retain information, most especially in the financial industry and even others, for tax purposes. That information should be retained within those periods of time. That's why we encourage, as data protection officers, that you should have a retention policy for your organization. Then the other is about quality. Quality is very key, because if you collect information and you do not have well-established processes for which you can ensure quality, making sure that one, whoever is collecting the information can ask the person whether they can confirm. This is best done on online platforms, whereby before probably mobile money, you send the money, or you sending whichever information to the other person, they give you ability to review that the information you've given is actually correct as the way you know it and it's complete, to enable you to, the data subject, to ensure that the quality principle is well observed, but even on the other side, they can be able to ensure that they are also observing it as an obligation. So as a data protection officer, advise on enforcement or applicability of this particular principle. The other is transparency. This is very key. Transparency starts, one, with letting people know that this is the information that we shall collect, who we shall use, what we shall use it for, whom you may disclose it with, which ideally is given in a privacy notice. So advise the institution to come up with the proper privacy notice that actually is able to inform, not one which is filled with so much information and someone cannot be able to understand what you're relaying, but there are various modes. You should be innovative. Of, let's say, if you're going to provide a service, yes, much information is going to be given to the person, but if I'm getting a ride-hailing company to give me a particular service, now, before I accept the privacy notice, probably you can bring up information that is relevant at that point when I've probably downloaded. One, why we need your location, probably why we may share it with another person, but then a link provided, what we call a two-layered notice, to let a person know that more information can actually be obtained at that particular point. The other is security, which has been properly dealt with, having safeguards in place to ensure the confidentiality of the information, restricted to only people who should use it or have access to it. Then the other is integrity, ensuring that it's not changed or modified in any way with unless you followed the proper safeguards. Then the last one is about making sure it's available in regard to having backup copies and all that. But of course, that is also informed by having an information security policy that the staff are aware of. So the designation, this one I'll run through it since it has already been dealt with. The Act requires every institution to designate a data protection officer to ensure compliance with the law, hinged on the accountability principle. But when we go to the regulations, next slide, the regulations qualify the instances or circumstances where a data protection officer should be designated. So next. So one, instances where this designation is qualified is where the activities of that institution, public body, or individual relate to processing operations whereby their virtue or scope or purpose require regular and systematic monitoring of data subjects. This is usually, I'll give an example of, I'll still go back to e-commerce companies. So someone can open up an account, but when you keep ordering, they can monitor your behavior, so that they can make recommendations of maybe, since you usually order for this particular product, we have an offer of a running discount, so that automatic or systematic monitoring of your behavior requires that institution to be able to designate a data protection officer. That's just one of the scenarios. Then the second one is, we can go to the next, where they are collecting special categories of data. So if you're collecting financial information, genetic data, racial or ethnic origin, religious or political affiliations, beliefs, then sexual life, such institution should designate a data protection officer. Why I included the name and date of birth, that's why it's in red. It's no, because that does not form part of the categories of special personal data. So those are the two instances mainly that the law gives. But however, we encourage institutions that, as out of good practice, you know, if you're able to have a person within the institution to conduct the role of a data protection officer, you can go ahead. But for those that having these particular scenarios or circumstances where you're processing personal data, for you, it is a requirement, it is a must to designate a data protection officer. So the responsibilities, they are also provided for in the regulations. One, you should maintain records of all your data processing activities. Now, one of the ways through which, we can go back to the slide prior, one of the ways through which this can be made easier on your part is that the very first role as a data protection officer is to register your institution. This one applies to everyone at the moment, as Stella pointed out, that will have communication gazetted of those that will be exempted. But everyone right now is encouraged. And when you register with us, the Form 2 and 3, they help you implement most of these responsibilities. Like records of data processing activities, it has that aspect of data mapping within the institution, knowing what personal data do you have, where is it located, is it in a manual form, physical records, is it in copy, then who has access to it. So as a data protection officer, those are some of the roles, they're maintaining those records, and of course in a secure form that you should implement. So the second responsibility, you can go to the next slide, is about responding to data subject and data subject requests and informing, rather you respond to their inquiries about generally what you do with their data, and then informing them how you use it. If you've disclosed it to any other person, which security safeguards do you have in place? This is ordinarily done using a privacy notice. So this privacy notice is further informed by Section 13 of the Act that states the information that you should provide a person. One, what do you collect from them? What do you use it for? Who do you share it with? How long do you keep it? And is it stored out of the country? So a data protection officer plays a key role in doing that. So then the other is the data subject access request. As you see there, someone will approach you and say, well, I've filled in the form because it's a right and there is a prescribed form that you use from the regulations, where a person will tell you, I need you to confirm if you have information about me and the details of that information. So as a data protection officer, if you do not have a proper record of your processing activities, the information you collect, it will be hard for you to actually honor this request. Reason being, it also has timelines within the law, but if you have this properly well mapped, you will be able to respond to it, because you stand a risk for your organization that if you do not, you're not able to honor it, a complaint can be made with us, and that will amount into an investigation that can carry a penalty when the organization is found violating the law. The other is about conducting regular assessments, which I was already talked about, the audits to ensure compliance. The data protection officer, still to add my voice to what Akil said, is that, to put it simply, is like the mini regulator. We are the regulator, the Personal Data Protection Office, but the person who plays the role of ensuring compliance with the Act and reminding everyone, conducting these audits and advising on how to mitigate the gaps is the data protection officer. So as an institution, you should be able to conduct these audits. You can have an audit plan or the regular assessments to check, and so that if later on we decide to, as an regulator, to come in and do an audit, if you have this record, it's one of the things that can show us that this institution is actually serious about compliance and it's taking steps to ensure that it's continued compliance and not just a tick box event. So the other, as already pointed out, definitely, which I've also intimated in my earlier submissions, is that data protection officer is the point of contact between us and the institution. So if there is a breach, we get in touch with them, we ask them for these records, if they've actually been implementing their roles, and then assisting, or of course, that's why you have these webinars, we also train them. Since we may not necessarily train everyone up to this level in the institution, so whichever knowledge that we pass on, all the activities, the data protection officer should be able to cascade the same within the institution. The data protection officer doesn't necessarily have to be an individual, but if the company or institution has resources, it can be a collaboration across board, an office, whereby this office is able to have representatives in different units and departments to ensure that actually it becomes part of the blueprint or the design of the organization, because as you know, the benefits of complying with the law. With that, I end my presentation, and we can use this remaining time to respond to your questions. If there are any which are specific to this presentation or generally, we are happy to receive them. Thank you.
Becca, thank you very much for your presentation. That was straight to the point. And yes, there are quite a number of questions, and we'll use the remaining 7 minutes to respond to these questions. So if you allow me, let me just read them out. Okay, so the data protection and privacy regulations, section 32, states that a data controller develops and implements appropriate security measures to protect personal data. So it doesn't mention specific ways to protect the data, looking at something like encryption in cases where entity uses obsolete, okay, or that's, so just to quickly respond to this question, the regulations are not strict in what appropriate security measures you're going to use to protect your data. Why? Because organizations are different, and also the type of personal data that they hold is different. Some organizations hold very sensitive data, and so they must put in place more stringent data security measures to protect that data. Then some organizations are small, and then other organizations are big and very complex. And then also looking at the resources that organization has. So the reason the regulations are not specific or stringent is because of the various types of data that we have, personal data, but also the nature of the organizations that we are looking at. So Paul, to answer your questions, this is something that the organization should do and look at in terms of how they are protecting their data. Okay. So I hope that really answers your questions or gives you clarity on this. And then also, once the data protection office comes into audit organization, then these things will come out if you've experienced a data breach or if you just picked on for a compliance audit. But the protection measures should be in tandem with the risk that your organization faces, so risk-based protections. Then there's another question, can you clarify on the recommended seniority for the DPO? Becca, could you take this, or do you want to take it with another question?
Okay, thank you, Angela. The seniority, we advise it should be someone at a senior management level. Giving specifics of government, probably someone, a director or a commissioner, so that this is a person who will be able to report directly to the probably the board to advise them on what to do, update them on compliance. So it should be someone at that level. But this is advisory.
Okay, thank you. So that's a general guidance. The DPO should be in a very senior position so that they're able to execute their duties in a manner that works. Because if they're junior, then that means the recommendations may go unnoticed. This ties in with William's question of who hires the DPO, management of good, of course, management.
Sorry, Angela, we can't hear you well.
Okay, let me just switch off my video. Am I better now?
Yes, much better.
Cool. So we have another.
Can you stop presenting also? Stop the presentation being projected.
No, this is your presentation that is still being projected. We're just on the Q&A and then we'll close.
Okay, you can go on.
How would compliance and enforcement be carried out against an extraterritorial company in the event of a data breach in regards to a Ugandan citizen? If you can take on that, and then we take on a few more questions.
Sorry, Angela, which question was that? There was a lot of background noise. I couldn't hear properly.
Okay, so how would compliance and enforcement be carried out against an extraterritorial company in the event of a data breach in regards to a Ugandan citizen?
Okay, the way we want, we know we are going to do it. Data protection commissions have collaborations across the world. Within Africa, we have the Africa Data Protection Commissioners Network, and we'll be able to utilize that information. Because if we know there's an organization that is breaching the law and is in the UK, we can liaise with the ICO organization, which is the regulator for data protection, to make sure that sanctions are taken against that organization. The other avenue that we shall take, or that is available, is that you can still sue within our jurisdiction here, because we are allowed to sue foreign companies. But of course, if a judgment is delivered against that company, we also have laws that enable reciprocal implementation of judgments in other jurisdictions. So it is possible to enforce against a company. It takes a longer time, but it is possible within our legal, within our jurisdiction. Thank you.
Thank you, Stella. We have an interesting question here that I'd like you just to follow up on. So if I'm not, okay, if you're not an advocate with knowledge of the data protection law, can I be appointed as a DPO? From the previous presentations, you need to have knowledge of the data protection laws or acts for you to fulfill your role as a DPO, not just the data protection law and acts, but also of your organization. So you don't have to be an advocate to be a DPO. So that's what you need to put in place. You must have the knowledge, you must have the trainings for you to really fulfill your mandate as a DPO. Otherwise, it will just be a role that you're not fulfilling, that you're not doing. Yes, can you lodge your complaint to the National Data Protection Office? Depends on the complaint, but we encourage you as a data subject to lodge your complaint first with a data controller that you have that complaint against. And if they do not, if the resolution does not satisfy you, or if they do not resolve your complaint, then you can log it with the Personal Data Protection Office. Now, Stella, this is the interesting part of the question. How comes that other countries outside Uganda have powers to order fines in case of non-compliance? And because the Uganda's case is not the same, does this weaken the Personal Data Protection Office?
Thank you for that question. Indeed, our law does not give us as an office powers to issue fines. However, it still provides for fines following a prosecution process. So different countries have different manners in which they apply penalties within their laws. In Uganda, there's a lot of hesitancy to give those direct fines. And I think you'll note that most regulators in Uganda are not able to issue those fines directly. The provision is provided for, but of course that fine has to be reviewed by a judge. So as an office, what we are doing, NITA already has an MOU with the Directorate of Public Prosecutions, And our focus will be in ensuring that, first of all, we do our investigations well, and then we work with the DPP office to make sure that prosecution is done as quickly as possible. And depending on the presentation that we make, we'll then make sure that the judges give the appropriate fines. Within the Data Protection and Privacy Act, the highest fines that we have are 2% of the gross annual revenue of that organization. We should also note that within the Data Protection and Privacy Act, a data subject under Section 33 of the Act, if they feel that they've suffered damage or distress through a contravention by a data controller, processor, or collector, is entitled to apply to a court of competent jurisdiction for compensation from that data collector, processor, or data controller for the damage or distress. In the earlier presentation done by Hercules, he did talk about class suits. This is possible because, yes, lawyers can use Section 33 to file a case. It may take longer, but it is going to happen. So those penalties are there and they are provided for. That is how we are addressing that. Thank you.
Thank you very much, Stella, for your very good explanation. So ladies and gentlemen, we have exceeded our time by 2 minutes, but if you allow me another maybe 4 minutes and we finish up a few of the questions, then we can close at about 12:40. So if that's, I hope that is okay with us. And then I'd also request my team to respond to some of the questions in the Q&A by typing in. And so we have, I'm just reading from the last one. Can the DPO role be added as an additional role to one of the senior managers? Yes, you can do that. The law provides for that. You can actually assign that role. You do not have to hire if you have the means to assign the role or you don't have the resources. Then when a data collector collects a data subject's personal information from a third party based on an agreement executed between the data subject and the third party permitting sharing of such information with partners, is it necessary for the data controller to independently seek the consent of the data subject for further processing of their data? So remember the principles of transparency. It's very important that the data subject knows that their data is being further processed by a third party. So as a data collector, you need to make sure that you have gotten the data subject's consent to transfer their data to a third party for data processing. That ties in with the principles of transparency. I think current regulations do not clearly specify where the DPO should report to. I think this is a gap that needs to be addressed. Could you respond to this if you're there, or okay?
You're breaking up. What was the question again?
Sorry, the current regulations do not clearly specify where the DPO should report to. I think this is a gap that needs to be addressed. Yeah.
Yes, we've already addressed that in our subsequent regulations on the DPO, especially when we specify which organizations must appoint a DPO. We'll address some of those things. However, our recommendation is that given the role that the DPO is playing, a DPO has to be at senior management level. Thank you.
Thank you very much, Stella. Then I have questions that have thumbs up, so let me just read them up and then we'll have a nice close. Are there penalties currently for organizations without data protection officers? I think Stella responded to this. Sent to be corrected.
I responded to that.
Yes, you did. Let me just close this. Okay, still an interesting one here. Does the Data Protection Office have input in the government upcoming requirement of people registering their motor vehicles and fixed with trackers? My worry is a concentration on corporate entities while not holding the government and authorities accountable. Still has a very good response to this.
Thank you, Emmanuel, for Mugahwa, for that question. Yes, the DPO is already aware of the intention by government to provide tracking devices for vehicles. My response is, one, the Data Protection and Privacy Act applies to all organizations. There are no exceptions for public bodies. Actually, the law specifically mentions public bodies for that same fear that Emmanuel will have. So yes, we are focusing on private and public bodies. In respect to the vehicle tracking system, we've already engaged Ministry of Security, and we've advised, and they've agreed with us to do a data protection impact assessment before they implement. So all these risks that will be identified will be addressed as they implement this solution. And the Data Protection Office will have a representative on their committee to make sure that these privacy concerns are addressed as best as possible. Thank you.
Thank you very much, Stella. And most of the questions are being responded to by Becca in the Q&A. So if you can go there, you'll find the responses. This brings us to the end of our webinar today. And so I'd like to encourage us to follow the office on PDPOUG on Twitter. And then I saw a request or a question on Twitter talking about, one of the users was asking, what are cookies? What are these cookies that we always click accept to, and we're accepting them? So we're looking to organizing another webinar that will specifically talk about these kinds of things, cookies and all. So ladies and gentlemen, it's been a pleasure hosting you as a Personal Data Protection Office, and we'll call it a wrap today. I'd like to inquire if our director has some closing remarks to say, and then we'll call it a wrap.
Thank you very much, Angela. First of all, I want to thank you all for attending this webinar. We know that the issues related to data protection and privacy are fairly new, even when the law was passed in 2019. You'll understand that we were not able to do a lot of awareness because the regulations were not ready, and even the office itself had not been set up. We are available to come to your organizations or through Zoom to be able to give you an overview of the law, to engage and make sure that we all are on the same page as regards data protection and privacy. As the DPO, as the Personal Data Protection Office, we have agreed to hold various webinars at least once every month. And this is our second webinar. We are going to do many more. Please follow us on our Twitter handles. We are providing a lot of information on our website. And of course, we are also available. If you need any assistance, if you want training for your staff, if you want guidance on how to proceed, we are available for you. And we are looking forward to hearing from you. Thank you.
Thank you very much, Stella. I see a lot of members are asking for the presentation.
Angela.
Yes, Stella.
I forgot to thank Hercules for making that very good presentation. As an office, we want as much as possible to engage industry experts, people who are actually practicing this trade, to be able to talk to you and give you more guidance as we also guide the industry. Thank you so much, and thank you, participants. Thank you for the presenters. And a shout out to Emmanuel Mugavi is a staff of NITAU. I've noticed he's been, providing a lot of clarity in the chat, and we thank him too. Thank you so much.
Thank you, Stella, for your closing remarks that have been very generous. And once again, I'd like to thank you, ladies and gentlemen, for taking off the time to come and attend this webinar. We hope and we want to see you again next month. We usually do these webinars the last Wednesday of the month. So just make a date with us on that date, and we'll have these discussions on data protection until they stop being a mystery. So from all of us at the Data Protection Office, it's a goodbye, and allow me to land this plane and see you again next month. Now, I'll keep the webinar open for a few seconds, a few minutes for anyone that would like to read through the chat or read through the questions, and then we'll close close the webinar. So thank you very much, and a good day to all of you. Take care and stay safe.